Welcome back to the Emily Show Monday edition. And yes, this week will be shorter than last week because these are supposed to be the quicker coverage of everything that's going on. But damn if the lawyers aren't trying to get in an entire year of billable hours in the month of January. And for those of you that are like, Emily, what are billable hours? Well, it's how most civil attorneys make their living by billing their client for their time. And the more time you spend responding to other attorneys and filing things in court saying the other side did it, well, the more billables you're going to be making, and some of these cases are coming in hot. So today we're going to talk about the lawyers getting feisty in both the Karen Reed case and the lively Reynolds, Baldoni, Wayfarer et al. Everything, a quick summary of what happened in court last week, what to expect in court this week, and an interesting ruling in the Keefe case that I think we're going to see ending up at the appellate court ahead of his trial for the shooting death of Tupac Shakur in Vegas in March. And so with that, if we don't get into it, we're just not going to finish today. So let's get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First, there were two cases that I've been following pretty closely in court this past week. And again, this is the Emily Show for Monday, January 27th. So last week, we had a 2-day hearing in the Kohberger case that is on the Quick Bits YouTube channel and on the audio feed that breaks down that hearing. But I also saw a lot of questions about it. Why was it in court? What does it mean? What's happening? First, the judge took everything under submission. He has not ruled yet. Judge H in Idaho said that he was taking everything under submission and would be submitting filings. There were more than 15 total motions on calendar, including motions to have a Franks hearing down the road, motions regarding that investigative DNA, and motions to suppress, lots of those. One of the questions I've seen a lot is when we're talking about DNA, what DNA are they asking to suppress? And why did I mention that that DNA won't be evidence in the case? When we are talking about the investigative or the IgG, the investigative genetic genealogy DNA, that is an investigative step before they identified Bryan Kohberger and before they tested the knife sheath found at the crime scene against Kohberger's DNA that they took from him when he was arrested. So those steps to get from an unknown sample from the knife sheath at the crime scene to starting to narrow down DNA comparisons before Kohberger was arrested, those investigative steps aren't going to be part of the trial, because the step that's going to be part of the trial is what was found at the crime scene, how was it tested, and then what DNA was it tested against, the defendant's DNA when he was arrested, and then his DNA was taken as part of that arrest. Those previous investigative comparisons are not going to be part of the trial because A, they aren't relevant, and B, they don't really help the finder of fact determine whether or not, when Kohberger was arrested, the DNA from his DNA swab and the DNA from the crime scene, whether or not those match, which is the ultimate question. We should see rulings from the judge pretty quickly. I imagine the judge isn't going to throw out all of the IgG DNA. The case law is not really strongly on the defense's side there. Neither are the facts. We will see if the judge orders a Franks hearing, and if he does, we will cover those hearings as well. And then we'll see what he does on the motions to suppress. But if there isn't an issue with that IgG DNA, a lot of the defense motions to suppress were based on that. So if that domino doesn't fall, then a lot of their arguments with regard to the search warrants later on aren't going to fall either. So we will see what Judge H does shortly. Also in court last week was Kouri Richins. Remember, she's accused of killing her husband with a lethal dose of fentanyl in a Moscow Mule. We have not seen as much conversation about this case lately, but it was back in court for the same type of hearing that we saw in the Bryan Kohberger case. These were suppression hearings and evidentiary hearings. But because Judge M in Utah does not want things streamed, and I don't know why, if there was ever a judge that looked like he was plucked out of central casting for a judge in a high-profile televised trial, it might just be Judge M, but no streaming out of that courtroom. We have to wait until it's uploaded in parts, and then I will be covering it this week. But Lots more information coming out about that case based on the witnesses that were there, because the defense is trying to suppress things like that walk the dog letter. And that, if you do not know about the walk the dog letter, I will link all of those videos down below because it's fascinating. It was a letter that was recovered from the defendant that seems to be her telling her family members what they need to say to support her defense, among other things, and her statements subsequent to arrest and search, among other things. No, the judge has not ruled yet, but yes, I will be covering that hearing this week. So make sure you have the Lawnerd app at lawnerd.com to know when I am going live to cover that hearing, because the witnesses are interesting, the attorneys are interesting, and that case is getting ready for trial in May. And we're going to hear more about the case than we've seen so far, because a lot has also been sealed in that case due to the amount of publicity, especially local publicity in Utah. And speaking of people waiting to go to trial, Keefe D is waiting to go to trial in Las Vegas regarding the 1996 shooting death of Tupac Shakur. This case has been pending for, well, more than 27 years, but this case has been pending for quite a while. If you have followed my coverage of this case, you'll know that Keefe D wrote a book talking about the fact that he was one of the last living eyewitnesses to the shooting death of Tupac Shakur, talking about himself and Suge Knight, who is in prison and has feelings about this case, and has, well, Suge Knight also has feelings about Diddy, which, because he has a podcast based on his collect calls from prison, has talked about in the past. But in his book, he talks about the fact that he had a federal immunity agreement with federal prosecutors to talk about what was going on with the shooting death of Tupac, Biggie, and others. This book is a retelling of the East Coast, West Coast rap beef from somebody who was right in the middle of it, amongst a lot of other things. It's a illuminating read. And he alleges in this book and elsewhere that it was Sean P. Diddy, Puff Daddy, Puffy Combs that ordered the hit on Tupac. And he maintains that that is accurate. But I have wondered what was going to happen with the state level prosecution in Nevada if Keefe D did have a deal with federal prosecutors, and if federal prosecutors in fact said, this is a deal for federal crimes. It doesn't mean the state can't prosecute you for state level crimes. And I wonder if releasing this book before he passed was a grave miscalculation or misunderstanding of what any federal immunity might have offered. But the court in Nevada evaluated whether or not there was any type of immunity deal that would, well, forestall him from being prosecuted in Nevada, and they ruled that there isn't. Again, you can release books after death. Just call it Life After Death. Wait, no, that title's taken. Emily, no, not the Biggie reference. You can release books after death, and maybe the truth would have been better shared then. But let's see what the AP is reporting happened in court in Nevada on January 21st. In a ruling Tuesday from the bench, Clark County District Court Judge Carly Kearney ruled that Dwayne Keefe D. Davis isn't protected against prosecution because he had not provided proof of immunity deals that he says he reached years ago with federal and local authorities while still living in California. Davis and his lawyer have argued that he should never have been charged with the murder because of those details. His attorney, Carl Arnold, said that the indictment against the 61-year-old client is an egregious violation of his constitutional rights because of a 27-year delay in prosecution, but the judge said she found no evidence that it was intentional. Right, because they didn't even serve warrants on him until after the book came out. Why are they prosecuting him? Because of the book. The book was a huge factor, I suspect, in prosecuting him and going forward with this, because the book lays out how everything went down in detail. What you say can be used against you. The book is the pinnacle of self-snitching. They go on to say that Arnold, the attorney, said after court, they will decide in the coming days if they will appeal the judge's decision to the state Supreme Court. I'm interested to see if they do. I will keep you in the loop. But again, if you put in a book, there are only 2 living witnesses to the death of Tupac Shakur and then list out how you brought the gun that was handed off to the gunman who then started firing out of the vehicle that then caused the death of Tupac. I just wonder how surprised he was when they went and served search warrants, and if he thought that whatever immunity deal there may be covered this. Again, I don't think it's too late for this not to go to trial. And I'm sure the feds have more questions about Diddy. And I wonder if Keefe is like, well, maybe there's a reason to have another chat. But I guess we'll have to wait and see. And in cases that are going to trial for a second time, we need to talk about this new filing in the Karen Read case very briefly. No, I have not covered the entirety of this filing on stream yet, but don't worry, I will on Tuesday, so make sure you join me on stream on Tuesday. The defense filed a 19-page motion talking about that video from the Sally Port that we saw in the first trial. You know, the "this shit is flipped" video where Sergeant Buchnick had to come back in the next day after telling the jury that it was an accurate representation of the Sally Port and then saying, well, it's an accurate representation except it's inverted. That video. The defense sent a digital expert to go and retrieve that video so they could evaluate things like the metadata and the entirety of the video and all the information you don't get when a video is turned over during trial. And yes, that particular video was turned over to the defense for the first time in the middle of that trial, which also is wild. The defense makes the compelling argument that because the digital recording system at Canton PD is set to overwrite every 30 days, and that video was provided for the very first time during trial, 2 years later, that somewhere it must have been saved. Somewhere it had to have been saved because it didn't overwrite after 30 days and just magically appear. It's not great when things overwrite. It can happen in cases when things overwrite every 30 days and maybe you don't know a location is relevant. There's no way anyone's going to argue to me that they did not know that Karen Read's vehicle was highly relevant to this case when it was brought into the Sally Port. You cannot tell me that they didn't preserve every single piece of footage from that entirety of the day. Why? Well, I, like you, have seen Trooper Proctor's text messages that were presented in evidence in trial, and Trooper Proctor is telling everybody that, Karen Read absolutely did this. So they knew well within the 30 days, they knew inside of like 30 hours that it was their theory of the case that Karen Read was the guilty party. So you can't tell me that you didn't perceive the import of the vehicle within the 30-day window to save all of the video. But wait, there's more. The defense filing asks for a little more than $12,000 for the time and travel of their expert, which is a reasonable ask, and with everything we've seen in this filing should be granted by the court, because when the expert got to Canton PD, the digital experts at Canton PD went, didn't we already give you that? And we don't still have it. And there's no longer an original here. And though this motion is for the cost of sending their expert on a futile errand because apparently the prosecutor didn't call and ask if there was still anything to download and told the defense, yeah, that's there. I don't know if the new special prosecutor checked or if they knew or if they didn't know. We're going to find out because this is going to have a hearing of some sort. But we also learn that on October 10th, 2024, after the trial, the Commonwealth provided video surveillance footage from Canton PD on the church side that shows Bryan Higgins, the ATF agent, arrive in the parking lot of Canton PD at 1:26 a.m., enter Canton PD, and speak to some unidentified individuals on the phone as he is leaving the Canton Police Department between 1:34:52 and 1:34:56. Significantly, this material and related evidence, which establishes Bryan Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left Canton Police Department shortly after John O'Keefe's death, was withheld from the defense at the first trial. And the defense asked at the first trial quite a lot of questions of Brian Higgins and his friend Brian Albert, because phone records show they had early morning phone contact. And the answers at trial from everybody were it was a butt dial. And also not just that it was a butt dial, but the butt answered the phone at some point, and that there was a short period of activation on the phone. However, having Higgins on the phone on video is a whole different thing than just having the phone records. And had that been turned over at the time, it could have opened up more discovery for the defense, because now we know that Brian Higgins' phone has not just been rehomed, but it's essentially been completely destroyed. So if this had been turned over when it should have been, then it might have led to other discovery for the defense. I am still surprised at the level of ongoing, I'll be generous and say incompetence, but I'm very interested to go through this whole filing with you, and I'm very interested to see how the Commonwealth responds to this. And the judge, give them the money. Karen Reed should not have to pay for the expert flying out when it could have been ascertained that that evidence didn't exist. The fact that the evidence no longer exists is a whole separate question, and the defense is going to be bringing motions relating to that, I'm sure, shortly. And finally, in cases that may never go to trial, we have to talk about the Lively, Baldoni, Wayfarer et al. Litigation that is just popping off with the lawyers getting feisty with each other. We are on the precipice of everyone asking for sanctions. There are allegations of violations of the attorney rules of ethics. And of course, we've heard Brian Friedman saying he's just going to put up a website with everything. Well, with everything they want to share. And whether or not that's permitted under the attorney rules is a question that's going to end up before the court. I think the court will probably want to have some conversations about that, because yes, there are questions about whether or not that could be the type of information that may prejudice a future jury down the road, with just information that is supposed to go through the courts and the rules of evidence and discovery and not be broadly publicized after a case has been filed. And there are multiple cases filed here, and the court actually put an order to show cause on calendar, but that order to show cause is why these cases shouldn't be consolidated. Right now they're related. That's just really procedural. I think the cases probably will be consolidated, meaning they're already related and in the same court, but everything's going to take place together. I think that's probably the right result for judicial economy, but we will probably see them back in court in somewhat short order, or at least the judge in writing telling everybody to knock it off based on these latest filings. It started with Lively's attorneys filing to the court saying, but Your Honor, they are saying all the things in public, and they put out video that will be evidence in court. And Lively's attorney said, and we believe that's improper. I have seen headline after headline that Lively's attorneys have asked for a gag order. That has not happened yet. In none of these filings do Lively's attorneys ask for a gag order. But what they did do is include perhaps a large miscalculation attached to one of their letters. And the fact that they did not see that this was going to go badly in a spectacular way is somewhat staggering to me. And not only is there a spectacular mischaracterization, but there is also an allegation that I find somewhat surprising and befuddling given how everything went down. So this first filing, there are now 3 in this series talking about what attorneys can and cannot say in the public. The first in this series was filed on January 21st, wherein Lively's attorneys included their prior cease and desist demands against Bryan Friedman. I'm not surprised that there was a cease and desist, because cease and desist are a, hey, please stop, or if you don't, we'll sue you. They're not uncommon. Like a demand letter, nothing's shocking to me. Except this one was a little bit, because this cease and desist was filed to the attorneys and a lot of the parties on December 20th. So on the precipice of the article dropping in the New York Times on December 21st, there is a seemingly proactive cease and desist sent to Justin Baldoni, Jamie Heath, Steve Sarowitz, Jennifer Abel, Melissa Nathan, and Jed Wallace and his company. It also is a preservation notice, which is a, hey, don't delete your shit. We're going to need it. Litigation is probably coming. But this cease and desist says our clients, and at this point, this is before the New York Times article, it outlines the represented parties as Blake Lively, Ryan Reynolds, and then all of their businesses. And then it identifies all of the Wayfarer parties, the PR parties, and more. It lines out all of the communications they say they have, that part of which are included in the New York Times article, part of which are included in that CRD complaint, the California administrative complaint. And it is telling them to stop making statements against Lively, knowing you're never going to convince me that Lively's lawyers did not know that the New York Times article was coming out. I guess maybe never say never, but it would take a lot to convince me that they did not know that was coming, especially with how intertwined the New York Times article and the CRD complaint is, and the fact that that administrative complaint was attached to the New York Times article via a link. That's where I downloaded it from. But what I also thought was wild, and this is buried in a footnote, they say that Wayfarers Counsel have attempted to justify their media campaign by noting that after they received the first cease and desist, they were contacted by the New York Times with a request for comment on a story regarding the CRD complaint. They go on to say, even accepting this is true, which it's stated in the New York Times complaint that I covered on stream, that the New York Times reached out to them with like a 12-hour window on a weekend and said, hey, care to comment about this complaint that was filed today? But we don't have a copy of that email. We have the text of that email typed into the complaint. But I don't doubt that the New York Times reached out and requested comment, because the New York Times said, here's the statement we received. And they posted that in connection to the lawsuit as well. And the New York Times isn't receiving a response from Brian Friedman if they never asked for a response to Brian Friedman. So it's just weird to me that even accepting that is true, because I think, oh, okay. I mean, I imagine that that's exactly what happened. Otherwise, they wouldn't have had the statement. I think res ipsa loquitur on that one for me, which means the thing speaks for itself. They go on to say that it would not authorize Wayfarers Counsel to continue to seek to influence the outcome of this judicial proceedings currently pending before this court. In any event, on information and belief, counsel for the Wayfarer parties voluntarily provided the CRD complaint to the press before publication of the New York Times articles, accompanied by Mr. Friedman's bombastic press statements and other details. So in the footnote to their filing, they allege that it was not them that, quote unquote, leaked the administrative complaint, but that it was in fact the Wayfarer attorneys that provided the CRD complaint to the press. They say that they provided the CRD complaint to the Wayfarer lawyers on December 20th, the day before the New York Times article. And we saw in the New York Times filing from the Wayfarer parties that this 4,000-word article they did not believe was written in a day. They allege that there was more time needed for the New York Times to review text messages and emails and the complaint. But Lively's attorneys have said that they provided that CRD complaint to the Wayfarer parties and allege that the Wayfarer parties provided it to the media before the New York Times piece ever dropped. I am still surprised. A, I don't think we saw anything in the media until the New York Times article dropped. And B, how do they know that? They then attach the two cease and desists, including the cease and desist from December 20th. But I can very well imagine how that cease and desist was received. But what I really want to know is, when was it received on the 20th? Because we know that it was about 9 o'clock at night when the email from the New York Times was received asking for comment per the New York Times complaint, which I can't imagine wouldn't be accurate. There's a paper trail there. So assuming that the New York Times complaint for defamation is accurate, when was this cease and desist received in relation to that email for comment? Because can you imagine the amount of lawyer rage receiving a cease and desist and then receiving a request for comment from the New York Times? I wonder if that backdrop informed the overwhelming level of drama in the complaint that was filed, not against the New York Times, but against Lively et al., because that complaint came in hot, incredibly hot. And I wonder if this cease and desist is part of what pushed that over the edge from we're going through litigation to, okay, we are just having an octagon style fight and we're going to see who gets tired of getting punched first, because that's what's going to happen in this litigation. Once you start receiving the lawyer bills and once all the parties start seeing how messy this can get, someone is going to want to tap out. And I think some of the strategy we're going to see is which side is going to try to force that tap out first. The rest of that filing does not ask for a gag order. It says maybe we'll need one down the road, but it brings up the ethical obligations of attorneys and very snarkily says, well, I can't believe a lawyer would do this. Really? But they, Your Honor, are bringing this to the court of public opinion when this should stay in the court of law, and we may need to ask for an order down the road. Well, that was responded to quickly by the Wayfarer team on January 23rd, stating to the court, quote, contrary to the inflammatory allegations in the Lively party's letter, counsel for the Wayfarer parties has not violated Rule 3.6 of the New York Rules of Professional Conduct. Rule 3.6 prohibits a lawyer who is participating in a civil matter from making extrajudicial statements that, quote, will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Putting aside that no such materially prejudicial statements have been made, and the parties are never going to agree on that, Rule 3.6d creates an exception to allow the lawyer to make statements, quote, required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Both parties are going to say in their filings and are saying in their filings, the other side started it, and I am just responding to what they're doing. The Lively parties are saying they started making all these statements in the public, and the Wayfarer parties are saying the New York Times article. I'm surprised that we haven't seen the Lively parties argue that the New York Times article was responded to because there was a response from Brian Friedman and try to cut it off there. But there has been ongoing publicity since then. And so they are going to continue to say, we are responding to ongoing publicity. And the Lively side is going to continue to say, no, you're creating the publicity, not responding to it. And those sides are not going to see eye to eye on that at all. Just at all. They go on to say, the Lively parties provided the New York Times with Miss Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department and, quote, thousands of pages of original documents, including text messages and emails. They go on to say in its bombshell story, quote, we can bury anyone inside a Hollywood smear machine. The Times regurgitated Lively's allegations along with an array of cherry-picked, altered, and misleadingly spliced communications. The results have been utterly calamitous for Baldoni and the other Wayfarer parties, who instantly became objects of public scorn and contempt. Already, the Wayfarer parties have been exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Miss Lively's scorched earth media campaign. Well, that's not the end of it, because Lively's side responded in court. And if anyone wonders why I like covering court filings, it's because they just always have the same order. Somebody makes a filing, somebody responds to the filing, then there's a reply to that response, and it's all, well, process. So in their filing on January 24th, and yes, this was just filed and we're already at docket number 39, the Lively parties respond again alleging that that complaint was leaked by the Wayfarer parties. They say, quote, Counsel for the Wayfarer parties attempt to defend Mr. Friedman's extrajudicial conduct primarily on the basis of what the quote, Lively parties provided the New York Times with Miss Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department and, quote, the Times regurgitated Miss Lively's allegations. Counsel for the Wayfarer parties appear to suggest that the reference conduct is permissible because, in their incorrect and baseless view, Miss Lively started it first. That is their view, that Miss Lively started it first. They have stated that repeatedly, so you have read that correctly. They go on to say, but the arguments that, quote, they started it is misleading and ignores the reality that the, quote, utterly calamitous effects that the Wayfarer parties claim to suffer as a result of reported facts and filed allegations were on information and belief initiated by the manner in which they or their counsel leaked the CRD complaint to the tabloid media. What? What? So the Lively parties are alleging that it was in fact the Wayfarer parties that leaked the CRD complaint to the tabloid media. It was attached to the New York Times article. When did it leak anywhere else outside of the New York Times? They go on to say that the Wayfarer defendant's assertion that no materially prejudicial statements have been made likewise cannot be reconciled with other of Mr. Friedman's public statements to date, and then they list a lot of them in a footnote. They say such repeated promises to take discoverable evidence and package it for publicity outside of the judicial context will materially prejudice the truth-seeking function of this court. Likewise, the claim that the Lively Reynolds parties seek a quote-unquote gag order is grossly misleading. This litigation is public. Requiring counsel to heed the ethical rules that bind them is not a gag order. It is a mechanism that would ensure the proceedings in this court are not prejudiced by counsel's conduct outside of the courtroom. I am very interested how the federal court is going to respond to the filings of, nuh-uh, they started it, and will probably advise and remind counsel that responding is different than creating the situation to respond to, but also the allegation that it was in fact the Wayfarer parties that leaked that complaint to the media before the New York Times had it is something I haven't seen any indication of in the record that we have so far. And I am surprised that that is the allegation, because it seems to me that the first time we all saw it, and maybe I missed something, was literally attached in a link to the New York Times article. That said, we will see how the court reins in what is in the public context, but it's clear that the parties are moments from all asking for sanctions. And I think we might hit a land speed record on when these attorneys start asking for sanctions against one another. This is not uncommon in civil litigation. I think it is one of the unfortunate things in civil litigation is that often it really does become a match in the octagon to see which party will tap out first. And I don't think that's going to slow down in this case at all. And because I record these with our lovely Law Nerd members in the Law Nerd Lounge and on YouTube, I saw a couple asking and wanted to address, so we all know, isn't it possible that that CRD complaint was retrieved from the public record? And that is a fantastic question, and I'm sure many of you have it. No, it's not possible. The CRD complaint is an administrative complaint. It is not a publicly accessible filing. The CRD complaints are not meant to be public. It is a mechanism that there can either be an investigation behind the scenes of a company, an employer, a workplace to see what happened, or you can get a right to sue letter and choose to sue publicly. So in California and other jurisdictions as well, you can have that complaint as the first step to filing a lawsuit, or you can go through the process administratively to try to resolve harassment in the workplace without it becoming so incredibly public, and be with in California, the Civil Rights Division doing the investigation of the workplace, not an individual and their attorney doing an investigation. And we've seen that in other cases I've covered, because we've seen the findings of the Civil Rights Division come into filings when a lawsuit happened after the findings from a CRD complaint. So unlike a lot of the cases we see where there's a public docket and the media immediately has something off of a public docket, like they, either knew it was coming or perhaps just have tremendous luck in searching for the right docket at the right moment. This is different because it cannot be publicly accessed on a docket anywhere. And that's a function of an administrative proceeding. So I'm very interested to see how this federal judge addresses the attorneys already ramping up the amount of filings in this case and already pointing the fingers at one another saying, no, you're the one making the statements that we have to respond to. Early in the proceeding, I imagine the judge will remind everyone that they are all attorneys, that they are appearing before the court, either pro hoc vice or otherwise, and that they are all bound by the same ethical obligations. And at the end of the day, we will probably see numerous requests for sanctions. Is that uncommon in civil litigation? No. This is just ramped up very quickly. And I wonder if the audacity of asking for a cease and desist to stop talking about Lively within a day of the New York Times article dropping, I just wonder if that maybe ramped the temperature up on how these parties and their lawyers interacted with one another. But I guess we'll have to wait and see. So we will be talking about this more, I am sure, but maybe not this week because we've got court to cover in Utah for the Kouri Richins case. And then on Friday, there is court in the Karen Reed case. And if you are hoping that the judge will address the latest filings by the defense on Friday when they have hearings regarding other experts, you are going to be disappointed. The prosecution hasn't filed a response yet. That is not what the court is having a hearing on Friday. I don't know if the defense will even bring it up, but maybe they will and ask for a date to have that heard before the court. But they're not going to take it up in such swift succession because the hearing for the 31st is already set to deal with whether or not there will be a future hearing regarding the defense's digital experts that the prosecution has moved to keep out. So we have a lot of court to get to this week. Make sure you have the Law Nerd app on your phone so you get notified when I go live to cover all of the things going on in the law. And I will see you live on Tuesday. Thank you for being here. Thank you for being a Law Nerd, and may the odds be ever in your favor. I'll talk to you in the next one. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.